7 long years in the making, the 2G verdict is finally here. In a landmark judgment, the special CBI court judge O.P. Saini has acquitted all the accused, including former Telecom Minister A. Raja, DMK leader Kanimozhi and a clutch of corporate honchos. The order has had some scathing words for the prosecution led by the CBI and the Enforcement Directorate. It's also had scathing words for officials of the Department of Telecom, which were in the line of fire. Ashpreet Sethi reports that closure in the 2G saga could still be some distance away as the CBI and the ED gear up to file an appeal in higher courts. But for now, it seems to be a setback for the BJP-led government.
A day of jubilation for A. Raja and his supporters who danced and burned firecrackers outside the 2G special court. Judge O.P. Saini has acquitted all those who were accused by the CBI and ED as far as criminality and irregularities in 2G spectrum allocation is concerned.
There is no material on record to show A. Raja was motherlode of conspiracy. With these words, Justice O.P. Saini issued 3 orders running into nearly 2,200 pages, acquitting all the 17 accused in the 2G case. The main protagonists claimed that they stand vindicated.
Are you happy with the order? Are you happy with the order? Yes,
I think the court's judgment has to be respected, and I'm glad that the court has pronounced unambiguously that all this massive propaganda which was being done against the UPA was without any foundation.
Being accused of corruption is not an easy burden to carry, and it has been very painful. But of course, it's a learning experience also, and politically I've learnt a lot.
The allegation of a major scam involving the highest levels of government was never true, was not correct, and that has been established today.
We've been able to prove today through the court verdict that we stand for truth and we were right. And as far as the Vinod Rai is concerned, he must be thrown out, dismissed from all the positions that he holds, because he has caused a lot of loss, not just to the credibility of the Congress party, but he has caused a loss to the credibility of the telecom sector.
As the Congress leaders claimed vindication, BJP hit back, reminding of the 2012 Supreme Court judgment, which had cancelled 122 telecom licenses allotted to 9 operators. Court had termed the licensing process arbitrary, capricious and contrary to public interest. The licenses allotted were declared illegal and quashed.
The Congress party leaders are treating this judgment as some kind of a badge of honor.
The policy was arbitrary and designed to promote corruption. It was implemented in an unfair manner. Now for this entire scam, who is liable?
2008 के ऑक्शन को लेकर के सीवीसी ने स्वयं जांच शुरू की थी और नीति को दोषपूर्ण माना था.
The BJP's own MP and a man who had moved the Supreme Court in the 2G matter, Subramaniam Swamy, took the government to task. Swamy said he has written to the Prime Minister about the failure of the prosecution.
Law officers were not serious about fighting corruption. And I would like the Prime Minister to take a lesson from this and set up a warlike council for fighting corruption.
Others like Rajya Sabha MP Rajiv Chandrasekhar, who had raised the issue in Parliament, also expressed shock.
There was wrongdoing has already been established by the Supreme Court. To argue that there has been no wrongdoing and he is justified and a zero loss theory of January 2010 is justified is all shooting, like building castles in the sky.
Justice Saini reserved some harsh words for the prosecution in the case. He said, and I quote, "I have absolutely no hesitation in holding that the prosecution has miserably failed to prove any charge against any of the accused made in its well-choreographed charge sheet." End quote.
Principle of criminal jurisprudence that the prosecution must establish the charges beyond reasonable doubt. In this case, the judges held that the prosecution has failed to do so.
All the corporate executives accused in the case have also got a clean chit. The 9 telecom companies which lost their licenses in the Supreme Court are now staking their claim for a refund from the government.
This is a case where Loop, which had paid 1,400 crores as the license fees, has to get refund now. The government must give refund of this 1,400 crores to them.
This 6-year trial may have ended, but the closure is far from over, with the case reaching the Delhi High Court next, as per the prosecutors. Outside Patiala House Court in New Delhi, this is Ashpreet Sethi.
Well, as Ashpreet Sethi was reporting, the CBI and the ED saying that they will appeal against the verdict, but Justice O.P. Saini spent an entire section of the judgment slamming the probing agencies and the prosecution. The judge said, and let me quote for you, "For the last about 7 years, on all working days, summer vacations included, I sat religiously in the open court from 10 a.m. to 5 p.m. waiting for someone with some legally admissible evidence in his possession, but all in vain. Not a single soul turned up," end of quote. He then goes on to say, and I quote again, "In the beginning, the prosecution started the case with great enthusiasm and ardor. However, as the case progressed, it became highly cautious and guarded in its attitude, making it difficult to find out what the prosecution wanted to prove. However, by the end, the quality of prosecution totally deteriorated and it became directionless and diffident," end of quote. Justice Saini also made some stinging observations against officials of the then Telecom department. Quoting a controversial clause in the DOT's rules, the judge said, and I quote again, "The term used in this clause include associate, promoter, stake, etc. No one in the DOT knows their meaning, despite the fact that the guidelines were framed by the DOT itself. In such circumstances, DOT officers themselves are responsible for the entire mess," end of quote. And finally, the judge goes on to say, "Nobody believed the version of DOT, and a huge scam was seen by everyone where there was none. These factors compelled people to conjecture about a big scam. Thus, some people create a scam by artfully arranging a few selected facts and exaggerating things beyond recognition to astronomical levels." That is the sum and substance of some of the operative paragraphs that have come in from that over 2,000-page judgment. Remember, there are 3 separate judgments running concurrently. We will discuss all of this with our eminent panel of lawyers and politicians. They're all here waiting with us. But a quick recap of what has been a dramatic day in court.
And I'm glad that the court has pronounced unambiguously that all this massive propaganda which was being done against the UPA was without any foundation.
Are you happy with the order? Are you happy with the order?
Yes. The whole thing has fallen apart today. I mean, after the judge has given his judgment.
नहीं कोई लॉस नहीं हुआ. आज अदालत ने सिद्ध कर दिया कि कोई करप्शन नहीं था और कोई लॉस नहीं.
There is nothing in this that the Congress party should consider it as some kind of a certificate.
Well, a day of dramatic developments. Joining me on the show, former Attorney General of India, Mukul Rohatgi, Supreme Court lawyer Sanjay Hegde, former Information and Broadcasting Minister and Congress leader Manish Tiwari. Also with us, Sanjay Kapoor, former CEO of Bharti Airtel. Gentlemen, appreciate you joining me on the show. Manish Tiwari, let me start by asking you, the Congress believes that today is the day that the Congress party, the UPA, finds itself vindicated. The Finance Minister's scathing rebuttal is, don't get ahead of yourself. The Supreme Court's judgment, the cancellation of the 122 licenses to 9 operators very clearly proves that there was corruption in the manner in which the licenses were given out. The Supreme Court called the manner in which you gave out licenses capricious and anti-public interest. So the government's response is, don't get ahead of yourself, don't wear this judgment like a badge of honor. Manish Tiwari, your response.
Well, Shreen, I think it's important to start right at the beginning. The first person who needs to stand up and apologize to this country is the former Comptroller and Auditor General of India, Mr. Vinod Rai, whose mythical Manohar Kahani called a CNDG report which alleged that there was a presumptive loss of 1,76,000 crores. As someone who had cross-examined Mr. Rai over 3 days in the Joint Parliamentary Committee, we had concluded even then that this report stood on the foundations of sand. And ultimately that got reflected in the JPC report, which was tabled in Parliament in the January of 2014. But in all the days of the general election,
even the JPC report, sir, even the JPC report. Even the JPC report, Mr. Tiwari, there were dissenting voices there. Report. Six members dissented. People like Mr. Yashwant Sinha called it a fraud, Manish Tiwari.
Well, the functioning of the Joint Parliamentary Committee is by majority. The report was adopted by majority. It was tabled in Parliament and Parliament accepted it. And now today, you have a trial court which, after extensively looking at the evidence, which after examining the witnesses, has come to the conclusion that there was no criminal culpability at all. And the Supreme Court judgment, which you refer to, with great respect to the Supreme Court, and I remember correctly that we had disagreed with the judgment even at that point in time, but then as it was a Supreme Court judgment, we implemented it in its entirety. Because if you were to rewind back to 1994, the policy of giving spectrum at administered prices held the field from 1994 right up till 2013. It went across the Narasimha Rao government, the Atal Bihari Vajpayee government, the Deva Gowda government, the Inder Kumar Gujral government, the Vajpayee government again for 6 years, and the Manmohan Singh government for 8 long years. And it was because of this policy of administered spectrum that you see the kind of tele-density that you have. You see the kind of low tariffs that you have in this country. If it wouldn't have been for a conscious policy decision followed by successive administrations, you would not have the success story which the Indian telecom sector is today. And so therefore, eventually, when you implemented the Supreme Court judgment and you auctioned spectrum, what do you see? That the entire telecom sector is today stressed. Why are they going to the government with a hat in hand, asking for bailouts, saying that we've paid exponential prices for spectrum, which has made our business completely unviable? Why do you hear all these reports of 4.5 lakh crore worth of bailout, 5 lakh crore worth of bailout is what the telecom operators are asking for?
Let's leave that aside. Let's leave that aside. You're saying that the practice of administered... You're saying the practice of administered pricing existed before the UPA government, as well as the first-come, first-served policy, which also existed before the UPA came into office. But Mr. Rohatgi, as the former Attorney General, as the former Attorney General, Mr. Rohatgi, let me ask you to comment, sir, on the charges that have come in from the BJP's Rajya Sabha MP Subramaniam Swamy. He has called it a complete collapse as far as the law officers of the government are concerned. He says he's written to the Prime Minister asking that this matter be taken up on a war footing. He's named you specifically as well, Mr. Rohatgi. I would first like you to respond to the charges being made by Mr. Subramaniam Swamy.
First of all, as I've already said on different channels, the allegations made by Mr. Dr. Swamy are completely baseless and they are malicious. I had appeared for some of these parties in securing bail for them in the Supreme Court much before this trial started. And after I became the AG, I had nothing to do with this case. The Supreme Court appointed a prosecutor, Mr. Grover, a senior respected lawyer. The Supreme Court appointed the judge who will decide this case, and I had nothing to do with it from 2014 when I became the Attorney General. And today is the first day I have commented after the judgment. So there is no connection between me and the prosecution. And as you know, a professional lawyer has his ethics. If he appears for a particular party, he can never talk to the other side or influence the other side at all. So the allegations are completely baseless. That's number one. Number two, as far as law officers are concerned, there was no other law officer who was concerned with this case except a special PP appointed by the Supreme Court, which was Mr. Grover. Therefore, whether they were able to prove their case or not able to prove their case was for them and for the judge. The judge has given his verdict, and that's where we stand.
Yes, the judge has given his verdict, but Mr. Rohatgi, let me ask you, sir, as the former law officer of this country, and you've made it amply clear several times over that, yes, you did represent people like Mr. Gautam Doshi who were accused, but since you took over as Attorney General, you've had nothing to do with this case. But explain to us, Mr. Rohatgi, given your legal experience, sir, what we've heard from Justice Saini saying that the enthusiasm and ardor with which this investigation started on behalf of the prosecution completely collapsed towards the end. In fact, he says, I don't know what they were trying to prove. How do you explain that, Mr. Rohatgi?
Look, as I said, I had nothing to do with this case. Therefore, this question ought to be asked to CBI or to the CBI's lawyer. I am only going by the judgment. You see, please understand, there is so much hype about this case, politically or media-inspired hype. The fact remains that in a criminal trial, the standard of proof is much higher than a civil trial. The standard of proof is to prove guilt beyond reasonable doubt. Cold and hard facts, a complete chain of events has to be shown before guilt can be established. The judge says that they were not able to establish the guilt. There must have been disjointed pieces of evidence. That is what has happened. Now, if the CBI is aggrieved of this verdict, or ED is aggrieved of this verdict, they have every right to go to a higher court and maybe plead that the judge overlooked some relevant evidence, or the judge has found a wrong rationale, etc.
And so that is the argument.
That, this case. So there's no question of...
Sure, that is the argument that the CBI...
So look, I mean, I don't think
that's
there's a question of any...
That's the argument that the CBI is making, yes.
No, what I mean to say is there's no question of... Yeah, CBI will do that. The higher court will decide. It happens day in and day out in thousands of cases. Appeals are allowed, judgments are reversed, High Court judgments are reversed by the Supreme Court. Supreme Court at times reverses its own judgment. So all this is a legal procedure which happens. I don't think it's a case of any vindication of any right or any wrong, or any vindication of any party stand, etc. It's a simple criminal trial.
Let the politicians
resulted in an acquittal.
Let the politicians play politics. Let the politicians play politics. But Mr. Rohatgi, I want to ask you, and then I'll get Sanjay Hegde also to comment, and get Manish Tiwari also to comment. Sir, people watching the developments of the day are scratching their head to say we've gone from a scam that was pegged at 1.76 lakh crores to today saying that there was no scam at all. In fact, if I can read what Justice Saini has said on page 1548, this is an over 2,000 page order, ladies and gentlemen. On page 1548, Justice Saini says, on account of various actions and inactions of the officials, nobody believed the version of the DOT. A huge scam was seen by everyone when there was none. These factors compel people to conjecture about a big scam. Thus, some people created a scam by artfully arranging a few selected facts and exaggerating things beyond recognition to astronomical levels. How should people understand this? The Supreme Court says we're cancelling 122 licenses given out to 9 operators. We don't care about the loss of economic value. And today, this judgment virtually says there was no scam at all.
Look, there is no doubt that the Supreme Court cancelled all the licenses because they found it was an arbitrary exercise of jurisdiction by the authorities concerned. We are not today debating the judgment of the Supreme Court, which was rendered 6 years ago. I think the correct way of putting it, if I were to paraphrase Justice Saini's judgment, the correct way is to say that no material or legally admissible evidence was brought before me to show that there was a scam. It's something like that. It's not like saying that, well, if it is night just now, it's not night, it is day. It's like saying, well, you talk about A, you talk about B, that A plus B is equal to C, but you are unable to prove it. So it's in that sense that you see it, not to say that there is a scam or there is no scam. It was not properly brought before the court in a legally admissible fashion. That's it. That is how a cold legal logic would say.
Okay, that's the cold legal logic. Sanjay Hegde, as I pointed out, people are trying to understand, grapple their heads around what has actually happened today. As Mr. Rohatgi pointed out, very simply, and if you look through this 2,000-page order, Justice Saini is saying no materially, legally admissible case has been built by the prosecution. He says, I sat for 7 years from 10 in the morning to 5 o'clock and nobody, not a single soul turned up with legally admissible evidence. The prosecution clearly seems to have failed to build a case, but that doesn't necessarily mean that there was no wrongdoing. That doesn't necessarily mean that there was no scam. Am I correct in my understanding?
See, let me put it this way. A man can be entirely honest, entirely non-corrupt, and a criminal prosecution against him may fail, but that doesn't mean that the man was not arbitrary. A man can take a right decision for wrong reasons and can take a wrong decision for totally extraneous arbitrary reasons, which can be set aside by a constitutional court using the administrative law lens. Now, as far as criminality is concerned, there you don't go on the policy, you go on the accused. Did the accused do a crime as defined in the Indian Penal Code, as defined under the Prevention of Corruption Act? Do his actions which are proven in court fit within the parameters of the section? Now, if you do not produce evidence, the burden is always on the prosecution to prove the case against the accused beyond reasonable doubt. The accused is entitled to sit on his hands or fold his hands across his chest and says, come on, prove it. If the prosecution fails to prove it, the accused is entitled to be acquitted and walk out of court honorably free of all allegations. That is what has happened today. The prosecution failed to prove its burden. The court says that I waited for anybody to come with legally admissible evidence. Nobody came for 7 years. You may say anything about a man. You may have all kinds of suspicions about the man. But to send him away under the Indian system of criminal law, you need proof beyond reasonable doubt.
You're absolutely right. Manish Tiwari, let me come back to you now. And, you know, the verdict is out. The verdict is clear. All 17 have been acquitted. But, you know, there was always this, there was always a needle of suspicion that was moving towards the role of the Prime Minister, the former Prime Minister Manmohan Singh, the role of the former Finance Minister P. Chidambaram. And let's look at what Mr. Saini, Judge Saini is saying. He says, who misrepresented the facts to the CBI versus A. Raja and others to the then Honourable Prime Minister? It was not A. Raja, but Sri Pulok Chatterjee in consultation with T.K. Nair, as he had suppressed the most relevant and controversial part of the letter of A. Raja from the then Honourable Prime Minister. Judge Saini there very squarely, very clearly saying that it was the officials in the Prime Minister's own office who were in fact responsible for not giving the Prime Minister, the former Prime Minister, the correct picture. In the Joint Parliamentary Committee, sir, you know, the JPC, what my understanding was, virtually had said that it was A. Raja who misrepresented facts to the former Prime Minister.
Well, Shreen, these are three separate issues, and let me deal with it one by one. First and foremost, I want to pick up on something which Mr. Rothgi had said with regards to filing of an appeal. The fact is that the CBI or the Enforcement Directorate is not a private agency. They perform a public function. And therefore, they have a responsibility to be fair and neutral and not be arbitrary. And even before a judgment is delivered, even before the ink has dried on the judgment, you know, you come to the conclusion that the judgment is wrong and it must be appealed. You know, everybody who's worked in government or who has a nodding acquaintance with government knows that there's a process which is followed. There is a Directorate of Prosecution which was set up and which is supposed to be independent post the judgment in the Jain Hawala case. That Directorate of Prosecution has to independently come to the conclusion that there are certain aspects of the judgment, you know, which require that it should be appealed or it should go through an appeal process. All this has been given a complete go-by. And an arbitrary statement has been made, oh, we will appeal a judgment. As you were pointing out, 1,556 pages is one judgment. There are two other concurring judgments. And you've come to a conclusion in the course of 3 hours that all the judgments are incorrect and they have to be appealed. What could be more arbitrary than that? And number two, with regard to certain aspects of the order which you referred to, I think, hang on. The difficulty is that an order has to be read in its entirety. You cannot selectively cherry pick something and then extrapolate it and ask questions that the judgment says this. Because ultimately there must be a certain context in which these observations or this arbiter or these findings have been reached. So therefore, let's peruse the judgment before coming to any conclusions that certain officers or officials in the PMO who've actually had sterling careers throughout. You don't become principal secretary to the Prime Minister.
I'm reading to you
if you've
verbatim.
not had a sterling career.
Reading to you verbatim.
And so there's...
Manish Tiwari,
I agree with you. I'm not disputing.
Sir, what the order says.
Shireen, I am not disputing what you are reading, but all I am saying is there has to be a context, and before perusing the judgment in its entirety, in order to selectively comment on some observations, I think is both unfair and completely incorrect.
Mr. Rodgi, if I could ask you a follow-up question, sir. We've been speaking with lawyers who represented some of the accused, and some of them seem to be suggesting that in light and in context of the order that's come in from Judge Saini, that, they should ask for a refund for the licenses that stood cancelled. It may be bluster, it may be nothing more than that, but do you believe that there is a case? Is there legal recourse for those companies whose licenses stood cancelled by that Supreme Court order in light of this order?
I think it's too premature to make any comment on that. One has to read the whole judgment, one has to see the Supreme Court directions and then make a comment. So I don't want to make a comment on what they say. I just want to add a final word before I go. As far as an appeal is concerned, I heard Mr. Manish Tiwari say about a directorate of prosecution, etc. But let me tell you, pretty much in the case of a first appeal, whether it's a civil matter or a criminal matter, by and large, a first appeal is kind of entertained at the instance of an aggrieved party. It is only after the High Court decides, and maybe if the High Court affirms the judgment, then a far more stricter scrutiny is required to see whether a High Court verdict should go to the Supreme Court. But in a case of first appeal, well, people have a right, whichever is the aggrieved party has a right to go up. There is no doubt about that. Thank you, and I want to leave.
Absolutely, they can appeal. Thank you very much, Mr. Rodgi, for joining us. That's the former Attorney General Mukul Rodgi responding to the charges made by Subramaniam Swamy of the BJP. Let me bring in Zafar Islam. Zafar Islam, does this now put the BJP on a back foot? Does this put you on a sticky wicket right through the 2014 campaign ahead of the elections? This was your big plank, that the UPA was the most corrupt government. The 2G scam was the biggest scam of that India has ever seen. Today, Zafar Islam, the Congress is saying, the UPA is saying, we stand vindicated. Does it put you on the back foot?
Not at all, Shireen. And why is Congress is thrilled with joy? Why there is excitement in Congress camp? They have not been absolved. They have not been... it is only D. Raja. In fact, Congress has to do a lot of answering, purely because if they were allowed for some time, I think initially there was a sense of excitement in Congress camp, but as they will go through the entire judgment, 1500 page, they will see that a lot of observations have been made by the judge about the conduct of the PMO. And that's something which needs to be questioned, that needs to be answered by the Congress camp and Congress party, because they are clearly absolved Raja. And no, secondly,
I have raised that issue, sir. Please respond to my question.
Shireen.
Well, the judgment acquits. The judgment acquits these accused. The judgment says that no credible proof has been brought to the table by the prosecution.
Well, Shireen, let me tell you that the judgment only absolves Raja, not Congress party. Secondly, it does not say that the crime had not been committed, because the evidence is in front of us, that how everything was managed, how favoritism was done by the then concerned minister, and how some companies who had no prior track record, credibility, credentials in place, yet they have been favored. On what basis? And how, as I was a banker at that time, I know the kind of rush few companies had to get the bank lines in place, just because they had to meet the deadline, and they were only hinted by the then minister that they will be considered. So nobody can deny the fact that the pricing, even one more thing, last thing, the price discovery was done in 2001. How can you, even if you take the inflationary impact, how can you take the same pricing in 2008? I mean, it's a simple logic. And I don't know why people are excited in Congress.
Manish Tiwari has already responded to that. Very quickly, Manish, I'll get you to respond. Why are you excited is the question there from the BJP spokesperson as well as from the leaders of the Bharatiya Janata Party, saying you have no reason to be excited. The Supreme Court order proves that you were corrupt, and this order doesn't exonerate you.
Well, first of all, to the gentleman who's representing the BJP, there's a difference between D. Raja and A. Raja. I think that distinction should be made very clear. Mr. D. Raja is a leader of the CPI and Mr. A. Raja is a leader of the DMK. I think there's a need to get facts in place.
I said
Number
the
two,
then minister.
what is also what is also extremely important is that by regurgitating allegations ad nauseum, you do not turn it into the truth. This is exactly what the Bharatiya Janata Party did from 2008 till 2017. And none of those allegations could actually stand the test of the courts. The entire case was tossed out of the window. And for the last 3.5 years, there's been a BJP government at the center. And number three, if it was only about A. Raja, why did Mr. Arun Jaitley, well, just hold on, I didn't interrupt you. Why did Mr. A. Raja, why did Mr. Arun Jaitley, Sushma Swaraj wipe out Parliament session after Parliament session, did not allow Parliament to function? They should stand up and apologize to this country that they became the cat's paw in this campaign of calumny, in this tissue of lies which completely derailed India's growth story, besmirched India's reputation and ruined innocent lives. That is exactly what this entire 2G fraud has done. The fraud investigation.
Let me just take that point forward now. Zafar, just 1 second. Please hold on. I'll get you a chance to respond. I'll give you a chance to respond. I've also got with me the former CAG official, Mr. R.B. Sinha, joining us. I'll come back to you, Zafar, in just a second. Mr. Sinha, I appreciate you joining us here on CNBC TV18. You've obviously seen the developments of the day and the order that's come in from the CBI court. Now, questions are being raised. The Congress party is asking for the apology of the former CAG, Mr. Vinod Rai. The Congress party believes that it was the inflated figure of 1.76 lakh crore rupees which has led to this entire hullabaloo about the 2G scam. Mr. Sinha, I want to ask you, sir, because it was reported that in 2010 you had written to the Deputy CAG, Rekha Gupta, alleging that you had been called by the chairperson of the Public Accounts Committee, a member of the Bharatiya Janata Party, asking you to expedite matters in the spectrum allocation case. Mr. Sinha, was there political interference?
Absolutely none. I don't think our CAG's reports were prepared very professionally, and I think based on the key documents, each and every sentence in the report has been included after a full examination of the papers. CAG reports are always based on the records of the government. They don't rely on any other thing. And our reports, our findings,
you stand by the,
were very clear.
By the figure of 1.76 lakh crores, Mr. Sinha?
Supreme Court also.
Since I have to leave,
I'll tell you two things here. We have not stated only 1 lakh 7.
Just a second, Manish. I'll get Mr. Sinha to respond and then get you to respond to him. Go ahead, Mr. Sinha.
Let me complete it. You see, in our report we had stated that the estimation of the loss could only be based on certain basis. So we had calculated the loss or estimated loss on 3 bases. The range was, there was a range, there was a span of losses. It started from nearly 58,000 crore to 1,76,000 crore. So out of 3, one method had indicated 1,76,000 crore. 2 other methods had said about 55 to 75,000 crore or so. But maybe media or maybe others for regions extraneous to them, they took it up 1,76,000 crore. Mind it, I would like to emphasize here. We had said that the FCFS policy, the policy which the government was following then, the same policy was not even followed by the DOT during that period. and we had stated not one. There were 4 regions, specific points we had stated that what are the points on which the FCFS policy was not followed, and that was accepted by the Supreme Court also. So Supreme Court also said that that FCFS policy was illegal, and they ordered that all natural resources should be auctioned. And thereafter, government has got 3,50,000 crores in 3 auctions.
Just hold on, sir.
2014, 2015, 2016.
Shireen, give me.
Yes.
Let me respond to.
That is former CAG official. Former CAG official there. Yes, go ahead, Manish Tiwari. The former CAG official sticking to the presumptive loss number that the CAG arrived at, saying why should the CAG apologize?
Well, no, but Shireen, let me respond. Let me rebut Manish Tiwari ji.
One second, Zafar. Manish Tiwari, go ahead. Zafar, I'm coming to you. Go ahead.
There was a gentleman called Mr. R.P. Singh who unfortunately passed away. He was the Director General of Telecom Audit at that particular point in time. He had given a loss figure of 3,000 crores, which was completely ignored without assigning any rationale. He was cut out of the entire process of formulating the report, and the entire report was done in a completely arbitrary basis. If you have time at some point in time, I can go chapter and verse, because since we had examined them all in the JPC, I remember all this very clearly. They were not able to substantiate their report. And Shireen, I'll have to leave with that. Thank you.
They were not... Thank you very much, Manish Tiwari, for joining us. Zafar Islam, respond there to the charge being made by Manish Tiwari.
Let me respond to Mr. Manish Tiwari.
Go ahead. Go ahead.
I just want to respond to Mr. Manish Tiwari. That he was asking for apologies from the Bharatiya Janata Party. Apologies for what? Exposing them how they have been architect to plunder the nation's wealth. Exposing them that how the Prime Minister's office were responsible for this kind of favoritism. Are exposed actually led to cancellation of licenses because they were done on arbitrary basis.
That argument has been made, sir, for years. Let's talk about specifics today. We have a specific order to discuss.
So,
let me go back to Mr. Sinha. Mr. Sinha, okay, that's the BJP's point of view. Mr. Sinha, you heard what the Congress leader Manish Tiwari had to say. He alleges that the 3,000 crore figure was kept out of the CAG report, that the CAG report inflated the numbers. Also explain to us, sir, why is there such a huge difference between what the CAG arrived at as a presumptive loss? You said that there were 3 different figures. The highest was 1.76 lakh crores. The CBI, in its 80,000-page charge sheet, has arrived at a number of 31,000 crores. Can you explain to us how there is this big difference?
You see, if I remember correctly, we had stated based on 3 grounds. First ground was that one of the applicant had themselves written to the government. They are prepared to pay so much amount for the spectrum if the spectrum is allotted to them. It was, if I remember correctly, Estel. Then based on that, we had calculated that the entire spectrum would have been given at that rate, and they were prepared to go even beyond that. So that the loss would have been in around 55 to 60,000 crore. Thereafter, another basis was if the 2G spectrum was to be auctioned based on the TRA recommendations of 2010 on the 3G prices, then it would have gone up to 1,76,000. The third one was that 2 of the applicants immediately after getting the licenses downloaded their shares to the foreign companies and as well as the Indian companies. On that basis, we have calculated that the entire spectrum would have been in the range of 60 to 70,000 crore. So there were certain solid bases. We had not gone to the market, we had not gone and taken any artificial assumptions, but the things which were just before us, based on that we had calculated. How have the CBI gone and calculated 30,000 crore? I think it is for the CBI.
That is for the CBI. Sure. Fair point, Mr. Sinha. Let me go across to Mr. Siddharth Luthra, senior lawyer representing some of the accused in the matter. Mr. Luthra, appreciate you joining us here on CNBC TV18. You know, to start with, Mr. Luthra, and this is a question that I've been asking to every guest that we've been speaking to on this channel, because there is confusion in the minds of people who are watching the developments of the day. For the last several years, we've had a Supreme Court order which cancels 122 licenses, which calls the licensing process capricious and against public interest. And today, this order, for the lack of admissible evidence, says that, you know, we don't know if there was a scam at all. And I'm again reiterating, for the lack of legally admissible evidence. Mr. Luthra, where do we go from here? Is this closure, or do you believe that this threat of appeals by the CBI and the Enforcement Directorate will have legs?
Let me clarify one thing at the outset. There are two different sets of parameters that are applied in terms of the test of evidence. The Supreme Court was essentially exercising writ jurisdiction, which is in the nature of civil jurisdiction, with a lower standard of evidence, which is preponderance of probabilities. In a criminal trial, it is proof beyond reasonable doubt. And that is what has turned the matter in the trial court. The trial court was looking at it, the actions being what they are. Is it a case of bad malintent on the part of the functionaries and the officials who've been prosecuted? And that was the examination that the trial court did. The Supreme Court took a very preliminary view because the consideration before the Supreme Court was based on affidavits and the records as they saw it.
Yeah.
In the trial court, the judge had the benefit of the witnesses coming, deposing, being cross-examined, being found to be failing and not being able to show and give an interpretation to the judgment. In fact, the trial court goes so far as to say that the CBI charge sheet misstates certain aspects. Now, I must tell you, there's a fundamental issue which we need to understand. The nature of investigations in this country need a serious overhaul, and we need to seriously train our officers to understand whether there is or is not criminality, because these are highly technical commercial transactions, highly technical transactions where there is going to be a release of government largesse. Now, as we change, as parameters change, as access to, as different forms of energy come into way, this is the case of airwaves, all of these parameters, there are no fundamentals. We used to have earlier the rule of tender, fundamental rules, financial rules, which could regulate when you went to buy, let's say, a computer or sell a computer. But today we have new areas which government is delving into. Government has control. They didn't even know what they have, and they're trying to release it in the public domain. So these are concerns which arise, and we may have an issue with the policy, all right. The policy may not be good, may not be fair, may not be balanced. That's the civil part of it. But to say there's criminality, I would submit, is absolutely abhorrent. And I'm very glad that we have judges of this mettle in the trial court who have looking and appreciating the effect of the Supreme Court judgment. Incidentally, that judgment was placed there, right? All those judgments were part of the record, and yet has found that the evidence does not meet muster, which is the most important finding, and it's a shot in the arm for the judicial system, for the fairness of the system.
Okay, shot in the arm for the judicial system. Sanjay Kapoor, the former CEO of Bharti Airtel, joins us. Sanjay, you know, a lot of the impact that the corporate sector faced has already sort of played out. A lot of the new telcos who were planning to set up shop, some who had set up shop, no longer exist in the country. A lot of the foreign players are out of the country. What does this now mean as far as the telecom sector is concerned? We've already seen significant consolidation take place. The weaker hands have exited the market, Sanjay. But do you believe that the impact of this now is more or less academic from a telecom sector's point of view?
Yeah, sure, Shireen. There was a scenario created in this country where a lot of people could enter this industry without fundamental business cases and without sustainable business propositions, just for short-term capital gains. And that's what crowded the market and took the market to a hyper competition. which was non-tenable, not sustainable, not heard of any part of the world. And I think that's what hit India. Today, a lot of water has flown under the bridge over the last 7-8 years. And the industry where it belonged to an oligopoly is where it has reached, right? So entire consolidation was on the cards because there was no viable business case for most of the players who entered the market at that stage, right? And we all at that stage also said that eventually we are going to move towards an oligopoly. And today we are entering an oligopoly. So what happened? Who gained? You know, the customers did not gain because the only thing that they got was pricing. They never got any experience out of it. The banks and the lenders did not gain. They're all facing haircuts at the moment. The operators who came for short-term propositions and gains, some of them made money and most of them are basically looking at an exit at any cost. The current and incumbent operators who are long-term players are the guys who had the worst possible fall in their profitability and their investments came to a standstill because of over-leveraging. So who gained? Nobody gained really in this proposition. Whether the loss was 176,000 crores or whether it was 30,000 crores or something lower than that, the fact of the matter is a key industry of this country that would have rendered India competitive versus rest of the world because our physical infrastructure is not strong and our virtual infrastructure had to be strong, was compromised, right? And that was compromised to an extent where today's judgment seems academic because it neither impacts or can restore the past, nor can it impact the future of this industry to frame it towards any betterment.
Sanjay Kapoor, you know, let me ask you this. Yesterday when we were talking on my show, both you as well as Rajan Matthew seemed to suggest that post this order there would be some sort of closure and that investors would actually welcome the closure. But given the fact that, you know, the future clearly is uncertain, but with this order, even the past is rendered uncertain. You know, what will this mean? What will be the big message that investors will take away? I mean, foreign investors, I don't know if they're looking at getting into the Indian market at this point in time, given the state of play. But what is the message that investors will take from this?
I think the message is a bit cloudy, I would say. You know, I don't know what will they make out of it. But if I was to translate it and say that, does it impact the stocks which are in the browsers in any manner? Or will it impact the valuations of companies going forward? I don't think so. I think the worst is behind us from that perspective. When this case was being tried, I think the investors penalized this industry as much as they could. So I think going forward, there'll be questions to say, what do we make out of investigations that happen here? But I don't think much more than that will translate into monies for this industry.
Okay, not much more. Siddharth Luthra, let me ask you a final question before we take a break.
On the road,
what kind of recourse do the... Very quickly, what kind of recourse do the accused now have who have been acquitted? I mean, we heard from lawyers of some of the accused suggesting that maybe this gives them an opportunity to seek a refund from the licenses that were cancelled and the license fee paid. Does this offer any opportunity of recourse for the accused who now stand acquitted?
I think the accused will have to wait. There is a 6-month period in which a bond is to be preserved because the CBIs or the ED are entitled to file their appeals. The appeals will have to be considered. However, if the appeals are not entertained or even earlier, the accused in these cases can consider filing for malicious prosecution. They can seek damages that they have been put to custody, they've been put to harassment and to legal cause. It's a difficult task, and most accused in this country, because having experienced 6 years of the legal system, they don't necessarily want to go back and seek compensation. They want their ordeal to end.
I would imagine.
But that is legally possible.
Yes.
That is legally possible.
That is legally possible.
The lesson that we really need to learn, and that is striking not only in this judgment of the trial court, but even in the earlier orders of discharge that were given in 2 of the other cases, is that we can't have public officials misreading notes that they've made, misrepresenting the file, leading to prosecutions of people, and then being caught out. Meanwhile, people have spent between 10 months to 2 years or 9 months to 2 years in custody. There's been legal costs involved. Industries have gone under. That's a serious lesson that is to be learned, and I think it's a wake-up call for government that whenever we are going to deal with issues which are arising, at least have a framework in place, and that is what this judgment speaks about, that you don't have norms, and yet you say there's a breach of norms. Well, how can there be a breach if there are no clear norms in the first place?
If there were no norms in the first place. You're absolutely right. We'll take a break on that. Siddharth, appreciate you joining us. Lots more to discuss. Wake up call. That's the message that's coming in from lawyers that we're speaking to. Our continuous coverage will return after this very short break.